Good evening. Um, just wanted to touch on an issue brought up by a really helpful viewer that shares a lot of things, from a claimant's perspective, and not a client, just someone I know from interacting online with comments and such. Anyway, he made a point that he thought that I think it was actually mentioned by an ALJ in a denial that his self-representation actually was one of the many crumbs I talk about that can go towards a denial or can go towards an award. It's usually not one thing. Unless you're a listing, then your medical evidence, boom, the numbers are exactly there. It's very objective. You meet a listing, it's over. Otis, stop barking. So his point was, the judge, the person had self-represented, which might not be such a big deal if your impairments are physical, because if you have no um, mental health limitations or mental health symptoms due to a condition, which, by the way, interferences with mental capacities can be based on physical problems, or they could be based on mental impairments. So this can go, a variety of ways. So it's not, across the board or anything like that. Do you like my new scarf, by the way? Um, I went to my thrift, and my big thing is jackets. And then I always wear my favorite and ignore the ones that don't become my favorite. But this was a scarf day, it's getting cold. Anyway, so I think, and I am biased, I think everyone should have representation unless you know you meet a listing. And the only way you're going to know that is if you understand the medical in the listing and then can actually pinpoint exactly in your records where it shows that you meet a listing. It's very difficult, particularly with certain things that are very complicated, certain listings, you know. So if anything is discretionary within a listing, you're not going to really know that it meets the listing, and it might not. So to make the assumption that you meet a listing is a mistake. But so after, if you don't meet a listing, then the next step in the process is that the judge will be looking at your residual functional capacity after he determines what that is. And that will be based on medical evidence in the file, as well as testimony that you give if you attend a hearing. So in that whole thing, they look at things you do at home from your function report, things you testify to, statements may be made by your doctors about what you did over the weekend, and things like that. Well, one of the things that would be considered is, how well do you handle your legal affairs? Bill paying, legal affairs, um, you know, if you're going to school and you're able to whack off some straight A's going full time, all those things are going to go towards your ability to do things you might say you have difficulty with: concentration, staying on task, being punctual, keeping deadlines. All those things require a bit of executive functioning, I would think. So when you self-represent, you're potentially saying to the SSA, and this is assuming you say that you have concentration issues, focus issues, mental health issues that prevent, strong concentration, strong focus, ability to stay on task. Some really important things, depending on your specific case, can be super huge. So when you choose to self-represent, and I'm going to address the choosing in a minute. If you choose to self-represent, you're saying, regardless of what you're saying in your claim, you're speaking through your action, your chosen actions. You're saying, I believe I am certainly competent enough to handle something as important as my disability claim that I know could take years. Yeah, I got it. I'm good. So what does that say? That kind of defeats any other claims where you're saying you can't really do complicated mental tasks. The research involved in getting it right, properly filling out forms, you know? So you're kind of telling a story here by your mere action of handling your own case. Now, if you have a physical case and you're not alleging anything in terms of a reduced capacity to think on complicated matters and take the steps necessary. If you're saying, no, I'm fine with all that, I'm disabled because I'm in a wheelchair, then that's a totally different story, by all means. But if you are saying that maybe you have pain limits, if you're saying you have serious pain and then it interferes with your ability to concentrate and you can't think straight when it's serious pain, and then you're going ahead and self-representing and doing all the paperwork and preparing your file and gathering medical records and doing all that stuff all in a timely fashion, of course. You're kind of refuting your own claim, potentially. If it's a mental, if it's chronic pain, which brings with it mental interruptions, if it's certainly a mental health case, not just a physical case with pain. And like I said, there are physical cases where pain is not your issue. That's not why you can't work. Then yeah, maybe you can totally handle your own claim. And of course, that it wouldn't necessarily be speaking contrary to that. But for a lot of cases, and I'd say most cases, it would be a bad idea because you are claiming pain or you're claiming mental health problems. That in and of itself right there kind of speaks to, why would you be self-representing? If you have such mental health issues that you're claiming they're so significant, I can't even do a simple, unskilled fifth grade job that a fifth grader could do. You see where it can be a little befuddling to an adjudicator or a judge? That is not to say I think that a judge would deny you solely because you self-represent. Not at all. I think he's going to find it if he finds it in the medical records, this is going to be a crumb that will help support his finding that you're not completely unable to do all jobs. I don't think a judge would use that and only that and then just ignore medical. I know they wouldn't. But keep it in mind, it can be one of the crumbs that helps support the denial. And since medical records are so difficult in terms of getting well-articulated records that show what's actually going on with you, I mean, the bottom line is our medical providers, by and large, and there are some good ones, so I'm not talking about them, are really, really poor at doing it. Whether it's a smack, cut, and paste, not that, anything you said to them, 90% of it never gets in your record about your complaints. These are the realities we're dealing with. So adding to that, the ability to self-represent when what you're saying is, I really can't stay on task that much because of pain or mental health symptoms or whatever. I think self-representing can be a factor against you. And of course, as you know, I represent people for a living. So I am definitely biased in the fact that I think people do much better with representation, assuming they pick focused representation by a representative who representing Social Security disability claimants or SSI claimants is what they do full time. They don't handle divorces over here or workers' comp over here, and then have a few straggling SSD cases and think themselves, Superman with them. I'm talking about focused, those that actually do it for a living, like many of us do. But I'm not talking about the practitioner who does a variety of areas, because obviously they're not going to be as focused and up to date on SSD, because you just can't learn 5 areas and be top of your game at all times. But if the bias I have is that I do think, and I think the numbers play out, that if you have a representative who is top of their game and focuses on Social Security, disability, and SSI, and isn't, throwing it on as a little gravy on their practice, I think the differences are huge. So I know a lot of people want to try to prevail on their case on their own so they can save on the fee. I get it. Do I think it's a good idea? I don't. I think it's kind of penny wise, pound foolish, but I get it. Particularly some who say, well, I'm going to wing it by myself on initial, And then if I get one denial, I'll read the writing on the wall and I will get help. All right, that's kind of understandable. Although you will have thrown in some, by and large, I don't think I've seen a single case where this isn't the case. You will have weakened your case by doing so if you get denied. You know, if you're the lucky one that wins, and I say lucky, I say that loosely. You're not lucky. You were found disabled. I get it. But if you do get found disabled without having to go all those 9 yards we have to go all the time, that's great. And it's a done deal. That's awesome. And you had no faith. But statistically speaking, that's not likely, right? So yeah, I got the bias going on. But from a objective point of view, as pointed out by this particular person who I thought it was well taken, and he pointed out that the judge actually pointed out in part of its support, and it was a mental health case, that self-representation, he was able to self-represent, do XYZ. It supported the denial. So take it for what it's worth. Noting, of course, I'm very biased for representation, and I mean attorney representation or non-attorney represent Otis or non-attorney representation, but only if they are astute practitioners and not, you know, jack of all trades, master of none. You might as well be self-representing, probably, if that's the case. But okay, that's it. Self-representation comes with maybe a double-edged sword there. All right. And that was one example of where it came to bite someone in the butt. All right. I'll talk to you later. Bye, guys.